Louise Abbott, an office manager in a doctor's office with the date of birth of September 21st, 1980, is on trial for grand larceny. Louise is accused of stealing $10,000 from insurance companies. The trial commenced in October of 2022, and Louise Abbott took the stand. On cross-examination, the prosecution tried to bring in Abbott's previous convictions to impeach the defendant's credibility. Here is how each instance went during trial. In 2014, Louise Abbott was charged with a felony conviction for criminal assault and was sentenced to 6 months in prison.
Objection, Your Honor. Under the 609A1B balancing test, you should exclude this evidence because its probative value does not outweigh its prejudicial effect.
Your Honor, under FRE 609A1, this is a felony conviction and is less than 10 years old, and the court should use 609A1B for analysis since the witness is a defendant in a criminal case. The probative value of this evidence outweighs its prejudicial effect to the defendant and must be admitted.
Under FRE 609A1B, when the prosecution seeks to admit evidence of a felony conviction less than 10 years old, and the witness is a defendant in a criminal case, the court must admit such evidence if its probative value of that evidence outweighs its prejudicial effect to the defendant. Let's see how the judge rules.
The court here finds that the probative value with this conviction does outweigh the prejudicial effect because it is less than 10 years old. Objection overruled. The conviction will be brought in.
In 2018, Louise Abbott was arrested for unlicensed vending. Abbott pled guilty to a violation and not a crime. Abbott was sentenced to conditional discharge.
Your Honor, this should be brought in because it's under 10 years old and it is probative of the defendant's credibility, showing the defendant's willingness to put her own interest above others.
Objection, Your Honor. Although the conviction is less than 10 years old, it was not a criminal conviction at all. Rather, the defendant pled guilty to a violation. Therefore, it cannot be admissible under any part of FRE 609.
Objection sustained. The court here finds that this is not a criminal conviction and is therefore inadmissible.
In 2015, Louise Abbott was arrested for a misdemeanor conviction for petty larceny. She pled guilty to a misdemeanor and was sentenced to restitution and community service.
Your Honor, this evidence should be admitted because it's not being offered for propensity purposes, but rather it's probative on the issue of the defendant's credibility. The conviction is less than 10 years old, and petite larceny is a crime that would be admissible under FRE 609A2.
Objection, Your Honor. This is not admissible under FRE 609A2, which provides that the evidence must be admitted if the court can readily determine that establishing the elements of the prior crime required proving or the witness admitting a dishonest act or false statement. In this jurisdiction, petty larceny does not require proof of or the witness is admitting a dishonest act or false statement.
Objection sustained. This evidence is not admissible under FRE 609A2.
In 2013, Louise Abbott was charged with a misdemeanor for being in possession of a forged driver's license. Abbott was sentenced to community service.
Objection, Your Honor. The forged driver's license is 9 years old and is irrelevant to the matter, and the defendant was sentenced to only community service.
Your Honor, under FRE 609A2, the evidence must be admitted as the conviction is for a crime that requires establishing or the defendant admitting a dishonest act or false statement. The possession of a forged driver's license is probative of the defendant's character for truthfulness, and the elements of the crime the defendant was convicted of requires proving or the defendant admitting a dishonest act or false statement. So this evidence is admissible. Additionally, there is no need for the balancing test under FRE 609A2.
Objection overruled. This would be admissible under 609A2. This conviction is less than 10 years old and it's probative of the defendant's character for truthfulness.
In 2002, Louise Abbott was charged with a felony conviction for criminal possession of a controlled substance. Abbott was sentenced to probation.
Mrs. Abbott, isn't it true that you were previously convicted of felony criminal possession of a controlled substance?
Objection, Your Honor. FRA 609B would be the governing rule in this matter, as this crime was committed over 10 years ago, and admitting it would be highly prejudicial because its probative value is not supported by any specific facts or circumstances, and its probative value does not substantially outweigh its prejudicial effect.
This is so old. 20 years? Objection sustained. The probative value of this evidence does not substantially outweigh its prejudicial effect or the risk of the jury confusing the issue of culpability for a drug crime with culpability for a crime of theft.